Welcome back, ladies and gentlemen, to this edition of Illinois Law. This evening I'm here with my guests Jennifer Shaw, Richard Wilson, and Rachel Toft, and we're discussing marriage and family issues as they relate to gay, lesbian, bisexual, transgender, and intersex persons. We've been talking about the relationship between the same-sex partners, but in this area, many gay couples today are having, adopting children, or have had a child because they've previously been married, or they've had a child out of wedlock. So what if a child is born to a couple? Does this change the nature of what their legal relationship needs to be? Are there things they have to do because they have a child or children in their home?
Absolutely. Just by virtue of having a child, that does not establish parentage. Unlike a heterosexual couple who has a child by virtue of their relationship, whether they're married or unmarried, parentage can be established. In the case of a same-sex couple, an adoption has to happen in order for parentage to be established.
So are you saying that two people can live together and one person perhaps comes to the relationship with an infant and they can live together for 20 years, and then if their relationship dissolves, the person can have no legal relationship with that child?
That's exactly what I'm saying.
This is really a critical distinction under Illinois law, because Illinois, unlike many states that are considered similarly progressive on topics such as this, still does not recognize what we commonly call de facto parentage or psychological parentage. That is a relationship that's established by duration and connection between an adult and a child. And too often this results in really tragic circumstances, because Illinois will not recognize parentage if it hasn't been legally established, and because of that it will treat the other parent worse than the horror stories you've heard about grandparents, for example. Because this person doesn't have standing to bring an action to enforce his or her rights or interests to the child. No standing at all. Without standing, they can't come into court.
Right. So they can't even go into court
right.
and say, Judge, but please understand,
right.
I've raised this child. I was the one who stayed home
right.
while she or he went to work.
And the case that resulted in that was just that kind of a case, where the woman who actually was what we would call the primary parent of the child, the relationship soured, the parties broke up, and the other parent happened to have been the biological parent, and it got awful and ugly and whatever. But this primary caregiving parent was completely shut out of this child's life. And it established bad law for Illinois that's been on the books now for 13 years that basically says if you don't have parentage, you have no rights at all. So we have this wonderful all and this horrible nothing. And if you have parentage, you have everything. You have a right to come into the divorce court and maintain an action for care, custody, control, education, support of your child, even if it's favorable. But you can adjudicate the rights of both parties equally. They're treated as equal, just like a divorcing couple in a marriage. They have all the benefits of a forum, of a court who will treat them as equals without regard to biology, without regard to anything, simply because they're both legal parents.
So are you saying that if a gay couple has parentage established, we're going to talk about that in a minute, what that means and how to do that, they actually, should their relationship dissolve, can use the domestic relation division, just like any divorcing couple, to adjudicate how things are going to go in the future? The visitation with the child, the custody of the child, any claim of child support for the child.
Any and all, because the custody provisions of the Illinois Marriage and Dissolution of Marriage Act define an action for custody based upon parentage without regard to whether there's a marriage or not. If they're a heterosexual couple and parentage hasn't been established because of DNA or other reasons, they're required to go to parentage court because it's under the Parentage Act.
Right.
But same-sex couples or couples without regard, they could even have broken up. could have not been living together for years, but each have been legally parents of this particular child, have a right to bring an action in the domestic relations division or the domestic relations courts.
Well, what about adoption? Is adoption available to gay and lesbian couples in Illinois?
Yes, it
Rachel?
is.
And for about how long has that been the case?
Since 1995, there's case law establishing that same-sex couples can adopt, same as single persons, married persons in Illinois. So it's quite open, as we were saying. You know, Illinois is pretty progressive on that front. That you can do a second parent adoption, you can do co-parent adoption, so you can adopt a child that's related, you know, to your partner and your partner's child, or you can, you know, adopt a child that's not related to either of you through foster care, through an agency, through private adoption. There's various other ways that you can, you know, adopt a child that's not related to you as well. So there's options
Indeed,
open
do
for
couples
family building.
do couples even hire surrogates and then adopt a child in that way?
Yes, that's a possibility as well. That there can be a egg or sperm donation, depends on, you know, what the couple is, and go through surrogacy, and then sometimes there would be the subsequent adoption by the other parent.
So it would be really important, I would think, that once you have children in a relationship, that you see that that child will be protected at least through its young years to the age of 18 and perhaps beyond in terms of financing college educations, etc. What happens when a gay couple's relationship breaks up and it does include children where there has been an adoption that occurs?
Well, and that would be similar to what Richard had just talked about. You can maintain actions for custody, you can set up child support, you can go to court and actually have the courts, you know, decide on, you know, the custody of the child, same as any couple that was married or any unmarried couple, heterosexual couple who had children together.
You know, sometimes when we talk in these shows, when we talk about what are our legal avenues, the couple themselves, though, is able to agree as to, or if they're able to agree, that's something that is also sanctioned by the court, can be sanctioned by the court. Isn't
Absolutely,
that true?
and typically what we do, it's really to bring in action not to shut the other one out, but to establish custodial rights and interests of both parties. And it's like a divorce, because essentially you're asking for a final judgment that declares the rights and interests of each party. And what's great about it is that the custody provisions of the Act requires the court to determine whether it's going to be sole custody, joint custody, what kind of a parenting schedule is going to be put into effect. And in order to get there, every county in the state requires that the parties go to mediation to try and resolve their whatever disputes or differences they may have before the matter proceeds further in court. So there's this emphasis on getting them to come to an agreement or getting them to come to a resolution. So the process is really not to shut the other one out, but just the opposite, to secure the rights of both parties, because the relationship itself is no longer intact, which ultimately will benefit the child more than not having an agreement, because it also can then guarantee support and other matters going forward.
So mandatory mediation for couples means all couples.
Yeah, we're under the Act. It requires that the parties mediate their disputes pre-decree. That would mean with children before the divorce, and disputes post-decree if they have, for example, a joint parenting agreement. But yeah, the process of getting to the agreement or getting to the resolution of the case requires them to go, at least in Cook County, twice to mediation through the Marriage and Family Counseling Service, or in DuPage County or in other counties. It's privately done, but it's administered through the courts. But it's always required before you're allowed to proceed with full discovery or with other matters.
Now, we're talking about adoption. What about guardianship? Is that an avenue that's available to same-sex couples?
It is. I don't know that it's as strongly favored as adoption, because a guardianship can be terminated by the action of one person.
That's true.
And so if you are not the biological parent, you do not establish parentage. All you are establishing with a guardianship is the right to make certain decisions for as long as that guardianship is in effect. And so when couples come to my office, I try to dissuade guardianship in favor of adoption, because it is a more permanent solution. But it is an option, and that's the sort of option that maybe If you are in a situation where the parental rights of the other party, the other parent can't be terminated, maybe guardianship is the only option that you do have.
And in terms of adoption as an option, people need a lawyer to have an adoption fructify?
Technically, no. However, adoption is a statutory creature, and it is very specific in its requirements. And if you're not completely correct, the adoption could be set aside. So it is one of those things that is much better had with an attorney.
And it's a long tradition in American law that we recognize not so much blood but relationships, and so adoption, and unlike most of the rest of the Western world, is a well-established legal foundation in this culture. And for example, all these disputes about same-sex marriage and recognition from state to state and full faith and credit, all of that's still up in the air. But one thing that's clear, adoptions are judgments of courts, and they are enforceable and entitled to full faith and credit throughout the 50 states. And there's federal law on that now. There is no dispute that a same-sex or a co-parent adoption from one jurisdiction is enforceable and legally recognizable in every jurisdiction in the country. So it's in everybody's best interest if it's available to secure it.
All right. That is a very wonderful place to end, and it's nice to hear that there's something that all 50 states recognize. Thank you, ladies and gentlemen, for joining me this evening for this edition of Illinois Law. And thanks to my guests, attorneys Jennifer Shaw, Richard Wilson, and Rachel Toft. They shared their knowledge with us this evening, and I know that you've all come away from this program learning something. Please join us next week for another edition of Illinois Law.